brought the request verbally. Obviously the court's read our renewed request and our points and authorities. We received the brief written by Mr. Ballard, which is very clear and very well written, and we understood the views expressed there. We just disagree fundamentally on what that code section means. We disagree fundamentally on the suggestion that there's a separation of powers problem. It is ultimately this court's responsibility to ensure that parties are represented by conflict-free counsel. Obviously, in the legal profession, there is an initial expectation that counsel will avoid conflicts. But there are always situations where a party needs to bring a conflict on the other side to the court's attention, and the court has both the statutory authority and the inherent authority under the common law to do something about it. So we do believe that this is well within the court's discretion. The statute actually tells the court that it needs to encourage the state to seek assistance. That seems to be a gentle way to say that the state is at least disqualified from litigating its own disqualification issue. And then I'm going to reserve the rest of my time for our evidentiary hearing and closing arguments.
Thank you, Mr. Novak.
Thank you.
Turning to the state, Mr. Ballard.
Your Honor, it feels like Groundhog Day. Here we are, we've got, again, we're supposed to be having an evidentiary hearing, and Mr. Gray should be on the stand, and instead we're arguing again this issue about whether this court can refer this issue to the Attorney General's office. And I guess if I were in Your Honor's position, I'd be wondering why the defense insists on raising this issue in a way that doesn't allow this court or the parties to be able to fully analyze it and brief it. The defense finally did file a written motion, but waited until Friday afternoon to file that. So as we've outlined in our alternative point in our response, I think this court would be well within its discretion to just deny that motion as untimely. But on the merits of that motion, I think as we've explained in our response, and Your Honor's indicated that you've read that, I think we've explained clearly why this statute does not apply in the way that the defense claims it does. And I'm happy to walk through the statute and the points that we've made. I don't want to belabor that. If Your Honor has any questions about the statute, I'm happy to answer those. But I think it's clear that this statute does not allow the court to replace a prosecutor. At best, what it allows is the court to recommend that the county attorney seek the help of the Attorney General's office. So I don't believe that this statute has any application. The cases that the defense has cited are irrelevant to this issue. And for those reasons, unless the court has any further questions about the state's opposition, I'd submit it.
Thank you, Mr. Ballard. Anything further from the parties before this court issues a ruling?
No, thank you.
All right. So before this court's defendant's renewed request to refer the pending motion to disqualify to the Office of the Utah Attorney General. In support of that request, the defendant relies upon Utah Code Section 17-18A-304, which provides that the Attorney General shall assist a county prosecutor only if the court finds that the prosecutor is unable to satisfactorily and adequately perform the duties of prosecution and recommends that the prosecutor seek additional legal assistance. The defendant argues that where there exists a non-frivolous basis, factual basis, suggesting a potential conflict of interest, the court should make such a finding and recommend assistance from the Attorney General. The court has carefully considered that argument and reviewed the briefings. However, the statute does not adopt the standard proposed by the defendant, nor does such a standard appear in existing case law or court rules. The statute requires specific findings, regarding a prosecutor's inability to satisfactorily and adequately perform prosecutorial duties before referral is appropriate. At this stage of the proceeding, the court is not persuaded by those statutory conditions have been met. Based on the record presently before the court, there is no indication that the Utah County Attorney's Office lacks the resources, knowledge, or ability to litigate the motion to disqualify on behalf of the state. Accordingly, the court cannot make findings required under Section 17-18A-304 to justify referral to the Attorney General's office. For these reasons, and without expressing any views on ultimate merits of the motion to disqualify itself, the defendant's renewed request for referral is respectfully denied. All right, counsel, let's go ahead and proceed. Mr. Ballard.
Thank you, Your Honor. Could I just clean up one piece of the record? Your Honor referred to the statute as 1718A, but I think it's actually been renumbered. It's 17-68-304 is the current citation.
Agreed.
Thank you. I appreciate that correction, and that is correct. I appreciate that, and to clarify the record, thank you to both parties. And so my ruling reflects that 17-68A-304. All right, counsel, are we ready to proceed with continuation of the direct examination of Mr. Gray?
Yes, except to quickly implement the exclusionary order that the court entered at the last hearing with respect to prospective witnesses.
All right, the court will take a very brief 3-minute break in order to accomplish all parties speaking with whoever needs to be spoken to and for them to be excluded, and then we will proceed. It is now 1:38. We'll come back at 1:41. The court is in a brief recess.
All right, it looks like they're still live, but they're frozen up. So while that's going on, Kelly, did you want to go over this? And everyone say hi to Blake. Blake, if you want to say something, go for it. We have a short recess here.
Okay, real quick. We had discussed a little bit about the speedy trial request on behalf of Erica, who is the victim's representative. I know there was some chatter about why is she considered the victim, given that she wasn't even there, but that's just what the court decided. So it sounds like they may be discussing this as well. It is interesting in Utah that this is not something that exists in all states, and apparently this law has not existed in Utah for very long. But you can see this, and this was filed right at the tail end of the day after the last hearing, or as that last hearing was going on, just about 2 weeks ago. What do you guys think? Do you think that, oh, okay. I see Chime expressed, do we like this judge? Just curious.
I actually do. I think so far he's not done anything that's disappointed me. He seems very just even keeled, even tempered, very fair. So I like how things have gone. The speediness could be the court's load could maybe be a little lessened, but it is what it is.
And I have a friend who I've been talking to for a while, and he's been a defense lawyer for many, many, many years for criminal cases specifically. And he's done some very high profile ones as well. And he says he likes this judge so far. So
Yep, I agree.
Stamp of approval at this point.
We should pull up the comment from ACE's 1138.
Is it recent?
Yes, at 240.
ACE's 1138. This one here?
Yeah, asking for a speedy trial tells me citizen journalists are close to finding the truth. I mean, I sure hope so. That was one of the things that I had crossed my mind when we got that kind of breaking news that evening. It's like, And I know I've seen several people in the chat saying, oh, it's only the defendant's right to request a speedy trial. But again, that is not the case in Utah. Victims are allowed to. Now, if it makes a difference, remains to be seen. But it's, if nothing else, it's just kind of a almost a ceremonial thing to do, you know, procedural thing to do, just to like reiterate, hey guys, let's keep this moving along.
Yeah, and guys, real quick, make sure you hit that like. It's the only thing that really pushes us out on YouTube. And also make sure you subscribe to Kelly Raybon. She's on YouTube, X, Instagram, and TikTok as Kelly Raybon herself. And then of course we have Blake. Did you want to spit your stuff out there, Blake? I don't have everything memorized for you.
Oh, sure. It's just Blake Bethnars on X, and then my YouTube channel is West Texas is the best Texas.
So make sure you guys go
Thanks.
support over there. And if you are on someone else's channel and you want to subscribe to me, I am Trigger Smart on YouTube and pretty much Trigger Smart HQ everywhere else.
Share the love.
We are
Definitely.
still-
I see some folks asking, what's the point of allowing a victim to be able to request that speedy trial? In some cases, you guys, defendants will, whether by strategic moves or just by happenstance, there will be delays and delays and delays. And, you know, sometimes people are just trying to like wait you out. And so I think, I'm not a lawyer or a practicing lawyer, you know, by any stretch, but it would seem to me that the point of this would be to tackle instances like that or to combat instances like that. But I don't think that we've necessarily seen enough yet to indicate that Tyler's folks are just stalling and stretching this out unreasonably. But
No, there's not been any indication of that. I mean, we're at the if this were a race, a marathon, we're at the part where you're lining up in your corrals I mean, the running hasn't even begun. So this is so at the doorstep of anything happening. It looks like this law came about in 1995, a legislature, Utah legislature with this 7738-7. So
Peter Panikin
1994.
says, is he appearing? If you're talking about Tyler, he's probably there. He was last time, but they're making all these things where they're saying that people are reading his lips on camera and you can't take pictures of him directly and stuff like that. So we may not actually see the camera pointed at him at all. And as soon as they come, I'm actually still monitoring and watching the court. So whenever that comes back on, I will switch it back over to that, but it's still currently in recess. And yes, Brandy and Billy, I believe I don't know if they're live yet, but I believe they'll be going live, doing interviews again outside the courthouse. I think they said 4:00 Central is when they were going to do that.
Wouldn't we'll have any surprises today.
Yeah, that would be, maybe they can find another key person that everyone's looking for. Yeah, it looks like they're going to be going in about like an hour and a half or so. They'll be going live doing interviews outside. Last time they found Travis. Well, he found them, I should say.
Wonder if he's there.
Oh, I'm sure he is. He's supposed to be a witness, I think. Back up.
so no audio on this.
Child be interviewed.
Yes,
There we go.
So it's your understanding that Mr. McBride advised SBI to do that interview?
that's my understanding.
Understood. Okay. You also testified on January 16th that you weren't really sure whether your office had a written policy for how to deal with either actual conflicts of interest or the appearance of conflicts of interest.
Yeah, I assume that they did, but I couldn't point to one at that time.
Okay. And then after the hearing, did you locate a written
I
policy?
did.
Okay. And at the time that you were discussing with the prosecutor whose adult child we're talking about, the fact that that child had been at UVU on September 10th and had witnessed many of the events surrounding Mr. Kirk's death, did you actually consult that written policy back in October?
No, but I followed it.
Had you previously read it?
I'm sure I had at some point. I mean, it's a pretty standard policy. If there's a conflict within the office, then, or a potential conflict, then the attorney will notify us, we'll review it and decide whether any action is needed, if at all.
Okay, but when
And
I'm
that's
sorry.
what we did.
When I asked you on January 16th, is there a written policy? Your answer was, I'm not sure.
Right.
There was a subpoena for documents that you received and complied with over the last week or so, correct?
Yes.
Okay. And one of the things that we asked for in that subpoena was any memoranda or writings that memorialized how your office handled the potential conflict of interest.
As I understood the subpoena, it's any discussions regarding whether or not there is a conflict.
Right.
And so
Did we freeze? Trigger, are you still there?
Yeah, I think we froze.
Okay. He may have frozen as well. Let's see.
Yeah, hang tight, everyone.
Okay.
The stream is running through Mr. Trigger Smart's page. So
Yep.
Kelly and I just are
We're
kinda
just,
sitting here as well.
yep, we'll keep you entertained. How about that? I think he lost his mouse. So I let's hope he means let's see. Oh man, I had my mouse here, but now I don't know where it went. Now I guess I lost my mouse too. Anyway, he said that his computer is okay for now. So in the meantime,
Do we need to put it up on? There
nope,
he goes.
he's working on it. We just entertain in the meantime. It's what
Hey,
they call
Kelly,
tab dance. Yes, sir.
let's go ahead and pull it up. I see J-Rock says I'm talking to my handler. I got something you can handle, J-Rock. So why don't we have you pull it up, Kelly?
Okay.
So go to YouTube and go to KSL News.
Yes.
We'll have you put it up and screen share. So if my computer goes down again, we won't lose that.
I
Hopefully.
do. Okay. I see what you mean. Gotcha.
Do you have a, let's see, there it is. And go ahead and full screen it and all that stuff. And
Your Honor,
make sure.
what I would like to do, if I may, is approach Mr. Gray with a document that I'm
Anyone,
just
is
gonna
it?
mark for identification as Exhibit
Yeah, go ahead and close their chat with the
I,
X
and that's
and then
Yep.
do
what
full
we've
screen.
previously
Yep.
marked for identification A through H, if I have my alphabet correct. And if I may pass one up to the court, I will, if the court needs that.
No, feel free to
How do I go full
approach
screen? Oh,
Mr. Gray and present
All right,
Exhibit
thank
I.
you.
hold on.
Gray, I'm handing you something that's been marked as Exhibit I for identification only. Oh, I'm sorry, of course. Have you seen this document before?
I've seen it, yes.
All right,
I mean, there's a lot more than just conflict in our best practices.
absolutely, but we're just
Yeah.
going to talk about that, okay?
Yeah.
All right, so what I'd like to do is turn your attention to page 2 of that document, which has a whole section addressing conflicts of interest. Would you agree with me that it starts in the middle of page 2?
Yes.
And you see what I'll refer to as general standard 1.30 conflict avoidance.
Yes.
All right, could you just read that aloud for the record, please?
A prosecutor should not hold an interest or engage in activities that conflict, have a significant potential to conflict, or are likely to create a reasonable appearance of conflict with the duties and responsibilities of the prosecutor's office.
What do you take to mean a reasonable appearance of conflict?
There has to be a real actual conflict, that there could be actually an appearance of that conflict.
And that would be in the views of the public, right?
That would be based on Supreme Court case law and case law generally.
But it's an appearance. What I'm asking you is, would you agree with me that there's an appearance to the public?
Objection. This calls for a legal conclusion, Your Honor.
Mr. Novak.
Well, the witness testified that he's been aware of conflict principles for 25 years. So I think he should respond to that question.
I think this is a good argument to have with the court after the evidence has been presented, whether or not there's an appearance of a conflict, what that means. But I don't think the witness's opinion about it is evidence.
Thank you. I'm going to sustain the objection. Mr. Novak.
Understood. Mr. Gray, why don't you turn to page 3, and that would be standard toward the bottom. 1-3.3C. Do you see that?
Yes.
Okay, could you read 1-3.3C aloud for the record?
If a prosecutor believes that public perception of the integrity of the prosecutor's office and public confidence in the handling of the case would negatively be impacted by a potential or alleged conflict of interest, the prosecutor should consider recusal.
All right, Mr. Gray, I want to ask you some questions about the decision to file a notice of intent to seek the death penalty against Mr. Robinson and the fact, which is beyond dispute, that a adult child of a member of the prosecution team was present at the shooting of Mr. Kirk, all right? You state in your opposition, well, let me back up. You testified on January 16th that you are the one who drafted the opposition to the motion to disqualify, correct?
Yes.
All right. So even though there's no affidavit by you, you stand by the contents?
Yeah, I said to the extent that we could either proffer that information or testify, and here I am.
Okay. So my first question is there a formal written policy or guidelines or procedure, I don't want you to get hung up on my nouns, for when your office decides to seek or not seek the death penalty in a case?
Anytime that it's an aggravated murder case, there's a potential for that.
Okay, so I understand that because that's what the statute says.
That's
But
right.
my question is there a policy, a procedure, a protocol, something in writing?
No,
Okay. And is it your view that it's your decision alone because you're the elected county attorney?
yes,
Okay. And in this case, did you discuss that question, whether the state should seek the death penalty, with your team before that decision was made?
yes,
And did that conversation include the adult prosecutor whose child is the adult student at UVU we're talking about?
no,
Are you saying that that prosecutor was specifically excluded?
Now, maybe I misunderstood your question.
Okay.
I thought you asked whether or not we discussed her status as a
Then
as a
let
witness
me back
there.
up, because it was a bad question if you didn't understand it.
Okay.
Those are the rules, right? Okay. So you discussed with your prosecution team whether or not the state would seek the death penalty against
Yes,
whoever the state accused of committing that crime.
yes.
And
I should back up. I mean, I don't know that we had a discussion before they actually had an arrest. I mean, that was 2 days later, but certainly in between the time that we filed and then we did have a discussion.
okay, so what you're saying, if I'm not trying to put words in your mouth, but just so the record is clear, is that after Mr. Robinson was arrested, your team had a conversation about whether or not it would file a notice of intent to seek the death penalty.
It was rather informal. I don't know that we all got together and said, what are we going to do? I would talk to different members of my team. But I had pretty much made up my decision. And so they knew where I was going.
Did you make up your decision before there was an arrest?
I thought that based on if we had the evidence that, yeah, we would be seeking the death penalty.
And you were already aware at that time that the child of one of your team members was present at that event, right?
Sure.
Now, what you're saying is that and that you discussed that with all of the team members, even if informally.
As far as the death penalty?
Yes.
Yes.
Okay. And you didn't exclude from that
No.
conversation the prosecutor whose child we're talking
No.
about. That prosecutor was included in the conversation
Yes.
about whether to seek the death penalty.
Yes.
And you're aware, because I think you were present, that there were a number of press conferences held by elected state officials both before and after Mr. Robinson's arrest, correct?
Yes.
Okay. The governor, who's a former licensed attorney in Utah, held a press conference on September 10th. Were you present there?
Probably. I was president at two different press conferences.
So there was one on the 10th and one on the 11th.
I know he made other statements as well, so I'm not quite certain. I know that I was at two different press conferences.
So when Governor Cox announced at a press conference that the state was going to seek the death penalty, had you already told Governor Cox that that was your decision?
I believe his statements, the only thing that I can remember of his statements is he said, by the way, or something to that effect, Utah has the death penalty. And so that's the one statement that I'm aware of. I mean, it wasn't exactly a demand for the death penalty, but so, I mean, the death penalty, ultimately, I made my final decision by the time we filed charges, if that's.
Okay, but the question I asked you was, had you discussed with the governor your intentions?
At some point, I did. I told the governor that I intended to seek the death penalty.
And was that before Mr. Robinson was arrested?
I don't recall if it was before or after.
Okay, I'm going to represent to you, and we can file an exhibit on this in a bit, that on September 11th, the governor said at that second press conference, we are working with our attorneys, getting affidavits so we can pursue the death penalty in this case, and that will happen. And you were standing next to him when he said that, right?
I probably was.
Okay. Had you already told him that you've discussed this with your team and this is our decision?
I may have. I remember telling him that I would be seeking the death penalty.
Did you tell the governor that the child of one of the members of your office was present at the shooting?
No.
Did you tell anybody else in state government that the child of one of the members of your team was at the rally?
Not that I can recall. It just wasn't part of my thinking.
Are you aware whether the member of your team told the governor or anybody in state government about that?
I don't know. Certainly not when I was in the room with them that I can recall.
Now I'm going to ask you the same questions about federal officials. Did you inform any federal officials that one of your prosecution team members, a senior member of your office, had a child who was there at the time of the shooting?
No.
Did you tell anybody in federal government or federal law enforcement that you were going to be seeking the death penalty before Mr. Robinson was elected? I'm sorry, before Mr. Robinson was arrested?
I mean, other than, I mean, when I talked to the governor, Kash Patel and Dan Bongino were there as well. So they heard my statement that that's what I intended to do.
Okay. And were you aware that before you filed that notice, the President of the United States went on national television, said, I hope he gets the death penalty?
I had heard that he said that, yes.
That was before you filed the notice?
Yes.
All right. Now, you stated in your briefing that your decision to file the death penalty notice when you did was partly because you ran for elected office 3 years earlier on a commitment to seek the death penalty.
Yes.
So you made a commitment. Sometimes we call that a campaign promise. I'm not trying to make light of it, but that is what we frequently call commitments that we make to the voters, right?
It was a commitment that I would seek the death penalty in all appropriate cases.
And you knew before you filed the notice that the governor thought it was an appropriate case
Yeah.
and the president thought it was an appropriate case.
Yeah.
Did Mr. Patel express his views?
Not that I recall. I mean, he was doing the bidding of the president. So, but I did find it a little interesting, Governor Cox, because he plays no part in the decision. So,
Did you tell Governor Cox after he made those public statements, this is not your decision, this is my decision?
no.
Was it important to you that the people you selected to be on the team for this prosecution remain on the team? I mean, you handpicked this team, right?
I did handpick this team.
Right. And the person whose child we're talking about is a longstanding, experienced senior member of your office,
Yes.
right? It
Yes.
was important for you that they be part of this case.
I want the best people on my team, and I believe I chose the best people.
May I have a moment?
Of course.
Thank you, Your Honor. We have no further questions for Mr. Gray. And if I may, what he told me is that he, after the examination, I assume that there's some cross-examination, he'll be available to be on call, so we don't need the court to address that with him, but he's going to leave the building,
Okay.
which is fine with us.
Yeah,
Thank
but
you.
I'll be available to come back if needed.
Thank you, Mr. Gary. Thank you, Mr. Novak.
Thank you. And I'd just like the record to reflect that it's 5 minutes after 2 when I've concluded my direct.
I appreciate that.
Did you?
Not yet. Not yet.
To the state, Mr. McBride.
I'm going to refer to the prosecutor in your office whose child was present at the shooting as Prosecutor A. Do you know who I'm talking about?
Yes,
Have you ever met Prosecutor A's child that was present at that shooting?
not that I could remember. I could have in passing, but not that I can remember.
Did Prosecutor did the presence of Prosecutor A's child have any effect on the decisions you've made in this case?
0,
Did that child's presence have any effect on your decision to seek the death penalty?
0.
Why did you choose to seek the death penalty in this case?
Because the evidence that had been gathered supports the aggravated murder charge, and I believe that the death penalty is entirely appropriate in this particular case.
On September 10th, you've testified that you learned that Prosecutor A's child was present at the shooting, correct?
Yes,
Did her presence affect the decisions you made on September 10th at all?
no,
Will you describe how her presence affected your decision-making on that day and in the few days following before you charged?
it had no effect whatsoever. I mean, quite frankly, as I think I testified earlier, I didn't even give it a second thought after I was told about that.
There's been some question about the reason you chose to seek the death penalty at the time you did. Now, the law in Utah allows you to wait to announce the decision to seek the death penalty until after arraignment, correct?
Yes.
Why did you give the notice of intent to seek the death penalty at the time you did rather than waiting?
I had learned from experience in a prior case, in particular, the Michael Jane case, that in a highly publicized case, the longer that you delay that decision, even though, I mean, I may very well make the decision early on, and I have in certain cases, but the more delay, then it just creates all this unnecessary public speculation and everything else. And we actually, in the Michael Jane case, I went to my attorneys and they said, yeah, we usually wait. But so I was waiting, but then Channel 2, I believe it was, contacted me and said that they had learned information that we were taking the death penalty off of that case. And so I had to hurry and call them before that, say that's not true. And within a month, I filed the death penalty. But it creates unnecessary angst with families of victims. I knew that this particular case was, I mean, talk about publicity. It's even more so in this case than it was in Michael Jane case. And I wanted to shut that out so that we didn't have to deal with that. And so that Erica Kirk didn't have to deal with that uncertainty.
Okay, as you made the decision in this, so that's the reason you made the decision at the time you did.
Yeah.
Is that right?
Yeah.
To avoid that uncertainty, speculation, and so forth.
Yes.
Was that decision made because Prosecutor A's child was present at the event?
No.
You talked about a campaign promise. When did you run for county attorney and make that campaign commitment to voters that you would seek the death penalty in appropriate cases?
It was
What year?
It was about 4 years from this very time.
Okay.
So
At that time, did you know Prosecutor A?
I knew of him, but I mean, because I had handled,
Had you met him personally and interacted with him personally? Or
No.
You just knew who he was?
Yeah.
Okay.
I mean, at some point after I won the election, I met with him and others to determine who.
Understood. But at that time, when you were making that campaign commitment, was it because you knew Prosecutor A?
No.
Okay. Was it because Prosecutor A had an adult child?
No.
Okay. Decision making. As far as the decision making in this case goes, who makes the ultimate decisions on major decisions in this case?
I do.
Does Prosecutor A, does the buck stop with Prosecutor A?
No.
There's been some evidence that deputy county attorneys in your office went to the command center at Utah Valley University on September 10th and the days after that.
Yes.
Is that a normal process?
Yes, in any homicide case or big case, we'll have attorneys respond to the command post to offer any assistance that may be needed, which may include search warrants or discussions about, the need for certain evidence.
So having attorneys appear at Utah Valley University that day was not unusual?
How many? I mean,
No. My question is, having attorneys
yeah,
appear.
no, not unusual at all.
Do you know which attorneys went?
Yes, I know that I went, Mr. Grunander went, you went, Ryan McBride, and David Sturgill went. And I don't believe any others. Somebody else may have gone there for a short period of time, but I don't recall seeing them there.
Did those attorneys go there because Prosecutor A's child was present?
Not to my knowledge, no.
Aside from charging, have many major decisions, aside from charging and the notice of seeking the death penalty in this case, have many major decisions been made in this case?
I mean, major decisions. No, I mean, what comes to my mind is one major decision was to make sure that defense counsel gets discovery in a timely manner. That was quite frankly foremost on my mind once we filed the case. And I personally directed procedures to be put in place so that there would be no mistake as to what the defense counsel received and what we had. I mean, every time there's a motion, obviously the team is working on it. We work on it together. But I mean, as far as trial strategies or things like that, none of those decisions have been made.
Is it fair to say that aside from charging and the death penalty decision, is it fair to say that the most important decisions are yet to be made in this case?
Yes.
And that includes trial strategy,
Yes.
preliminary hearing strategy,
Yes.
any plea negotiation.
Yes.
In all the decisions that have been made up to date, has Prosecutor A's child come up in those decisions?
No.
I should say aside from this motion.
Aside from this motion, yeah.
And so aside from this, I'm going to ask that question again to make sure the record is clear. Aside from this motion to disqualify the Utah County Attorney's Office, has Prosecutor A's child come up in any of the decisions made in this case?
No.
Has Prosecutor A's involvement in this as a witness here affected the prosecution in any way in this case, in your opinion and observation?
No.
Do you believe it will affect the prosecution in the future?
No.
Why not?
Because this is somebody that happened to be there. That has, what we're concerned about is the evidence supporting the charges. That's first and foremost. And that has nothing to do with somebody that happened to be there. Quite frankly, completely irrelevant to anything that matters in the case.
Okay. A couple other follow-ups. Earlier, you testified that Prosecutor A received a you were with Prosecutor A when Prosecutor A received a message from his child that Charlie Kirk had been shot.
Yes.
Is that right? And then you testified that Prosecutor A left to go to the scene. Do you know why Prosecutor A left? Was it to go to the scene and help law enforcement or to be with his child?
To assist in any way we can with law enforcement.
Okay. You previously testified that you did not consult the Attorney General's office about whether or not this was a conflict of interest that would require your office to leave the case or to refer the case. Why did you not consult the Attorney General's office?
Because what they would have done is, researched it and then come back, and I've done that for, over 30 years in my practice. I'm capable of doing that.
Researched it where?
Case law and so forth. Again, I mean, I do not believe that there's any conflict whatsoever. I made that conclusion. I stand by that. I mean, out of an abundance of caution, we certainly notified counsel out of an abundance of caution. And I think that's the appropriate action to take. So again, I understand what the concern about conflict is whether or not it has any possibility of affecting your decision-making as a prosecutor. And I didn't see how this does in any way.
Okay, if I can have just a moment. You said you had some neighbors that had children that attended the event where Mr. Kirk was shot.
I was told that they were there. Yeah.
When did you learn that those people were there?
I don't know, a couple weeks after, I believe, after the event.
After the charging decision was made?
Yes.
How closely do you know the children that were there?
Not well at all.
Okay.
I mean, maybe a hello or something out on occasion. But as far as I know, I'm not even sure that they even live in our ward at all at this point.
Okay. Thank you.
All right. Mr. Novak.
No, thank you, Your Honor. I don't have any redirect at this time.
As previously discussed, may Mr. Gray be excused?
For now, yes.
Thank you. Thank you, Mr. Gray. Mr. Novak, your next witness? Or I'm sorry, Ms. Nestor. Your next
Your Honor,
witness.
at this time, we were going to call the adult child, but I believe that individual's attorney, they're ready? Okay, then they are ready. So we would like to proceed with calling the adult child at this point. I think it would be appropriate to hear whether or not we close the hearing or at least come up with some ground rules about preventing any photography or mentioning of her name, however the court desires to handle it.
Thank you. I'll hear briefly from the parties. I did read the proffer of facts regarding the closure of portions of the evidentiary hearing on the motion to disqualify the Utah County Attorney's Office. And I'll hear any additional argument or statements prior to making a ruling.
Your Honor, Ryan McBride for the state. We do move to close the hearing for the testimony of the adult child. I think the rationale that I explained previously still stands. The rules of judicial administration allow closure for privacy and safety reasons. I believe with the proffer of facts that the defense has accepted here, we have shown that there are privacy and safety reasons that favor closing the hearing. Defense counsel has stipulated a closure of this portion of the hearing. The media in the past has stipulated to closure of the hearing. I think the record is adequate. I think the safety concerns support closure. And absent any questions from the court, I would make that motion now.
Thank you. Anything further from the parties?
No objection, Your Honor.
All right. So the media, the prosecution cited to the media. Did you want to weigh in?
The media does not object to the closure of this portion.
Thank you. The court has reviewed the parties' prior arguments and materials submitted in advance of today's hearing, including the filing entitled Proffer of Facts regarding closure of portions of the evidentiary hearing on the motion to disqualify the Utah County Attorney's Office. The defense has requested that the testimony of certain witnesses, specifically Prosecutor A, an adult child witness, be received in a closed session pursuant to Utah Rule of Judicial Administration 4-202, citing concerns related to personal privacy and safety. The court acknowledges that Rule 4-202 permits limited closure of court proceedings in appropriate circumstances. At the same time, this court is required to consider countervailing interests identified in Rule 4-202, including the public's right to observe the conduct of public business, to understand the operation of government, and maintain confidence in the judicial process. This court must also be mindful of the constitutional rights of Mr. Robinson, as well as the constitutional and statutory rights of Ms. Erica Kirk in her role as victim representative. The purpose of today's evidentiary hearing is limited and specific. The court is asked to consider the defendant's claim that a member of the prosecution team, referred to as deputy county attorney in one of the motions, has a personal conflict of interest, that any such conflict extends to the Utah County Attorney's Office, and that disqualification is therefore required. The court's role at this stage is to receive relevant evidence and to rule based on the record and applicable law without reaching the merits of those claims in advance. The parties have filed public motions outlining the anticipated evidence and testimony related to the motion to disqualify, including the state's opposition, the defense reply and request to take evidence, and the defense original motion. Those filings describe the general subject matter expected to be addressed at today's hearing. If the adult child witness is called to testify, which is the request at this point, the court will consider that testimony as part of the evidentiary record. After careful consideration of the record, the arguments of counsel, and the interests identified in Utah Rule of Judicial Administration 4-202, the court finds that closure of the adult child witness's testimony is not necessary and would not be narrowly tailored under the circumstances presented. The court further finds that the interests of openness and transparency outweigh the asserted grounds for closure as to that testimony, and that the rights of the parties and witnesses can be adequately protected through least restrictive means available to the court. For those reasons, the request of both the state and defense to conduct the adult child witness's testimony in closed session is partially denied. The court acknowledges that Utah Rule of Judicial Administration 4-202 permits limited closure of court proceedings in appropriate circumstances, and also acknowledges the concerns raised regarding the personal privacy and the safety of the adult child witness. This court's responsibility is to balance those concerns with the constitutional rights of the parties and the strong presumption in favor of open and transparent judicial proceedings. Therefore, the court finds that a brief and narrowly tailored procedure is appropriate to address these competing interests. Accordingly, the courtroom will be temporarily closed, and all parties and members of the media will be excluded for the limited purpose of calling the adult child witness to the stand to state identifying information. Once that limited portion of the proceeding is complete, the courtroom will be reopened and members of the public and the media will be permitted to re-enter. During the testimony of the adult child witness, no audio or video transmission will be allowed and no photographs of the witness will be taken. At the conclusion of the adult child witness's testimony, audio and video transmission of the hearing will resume and will continue through the remainder of the proceedings. The court finds that this procedure is narrowly tailored, uses the least restrictive means available, and appropriately balances the interests of witness safety and privacy with the public's right to observe these proceedings. We will proceed accordingly. We will take a brief, we will go ahead and clear the courtroom and go into a closed session. And the only remaining parties will be the attorneys, and we will take it from that point. Court will be in brief recess for 2 minutes.
All right.
So Kelly, we can just mute it. I already muted it, so we can still watch when it starts again, and then feel free to chat.
Okay. Well. Okay. So
First thing is this adult child label. I don't know if that's a legal thing, but if you're an adult, you're an adult. I get that it's the child of someone there, but it's still an adult. So the fact that they're closing it all up seems a little strange to me. Now, if that was my kid, would I want to do that? Of course. But it still seems like there's a little lack of transparency. What do you think, Blake?
Yeah, I'm totally with you. It's just very ironic that we've got an adult child as being referenced here. I guess it is the fact that the female is an adult and who happens to be the child is how I'm drawing that.
It just sounds so ridiculous. And I mean, talk about coddling. Like, come on. I mean, it's important enough to hear public testimony and have it be included in a murder trial, yet it can't be public.
Right. And I mean, this whole thing about the protection status and whatnot, I mean, we're talking about just some random witness that was there that just, I don't see the leap there that they're making. But I guess it's a win and a loss on what they're going to show.
To people that are asking about cameras, so basically, as I understand it now, cameras are available to be there, and so is audio and everything else. Everything is open within the judge's. He basically gets to decide. Like this case right now, with this adult child, he is choosing to close the court. But in general, everything should be open. But if they keep doing this pattern where they keep closing it in certain pieces, then is that really transparency?
Yeah, no, it's not.
Only partial. But hey, I mean, we'll take what we can get, I guess, at this point, just like with everything else. We have to, eat the Fed slop or go hungry and try to find scraps on our own. So that's kind of how we roll.
Hey, Kelly, could we listen to that one more time? Like just the part where the judge lays down, just so we can, I'd like to listen to it one more time. If you can bring it up.
Let me see if I'm able to go back. How far back do you think? Maybe
It was right there
couple
before
minutes, like maybe
it went into recess.
4
Yeah, it was
minutes.
right there.
4 minutes.
Yeah,
Okay.
Will be permitted to re-enter. During the testimony of the adult child witness, no audio or video transmission will be allowed, and no photographs of the witness will be
keep going
taken.
back, Kelly. Just about another 2 minutes.
Thank you. 4-202 permits limited closure of court proceedings in appropriate circumstances. At the same time, this court is required to consider countervailing interests identified in Rule 4-202, including the public's right to observe the conduct of public business, to understand the operation of government, and maintain confidence in the judicial process. This court must also be mindful of the constitutional rights of Mr. Robinson, as well as the constitutional and statutory rights of Ms. Erica Kirk in her role as victim representative. The purpose of today's evidentiary hearing is limited and specific. The court is asked to consider the defendant's claim that a member of the prosecution team, referred to as deputy county attorney in one of the motions, has a personal conflict of interest, that any such conflict extends to the Utah County Attorney's Office, and that disqualification is therefore required. The court's role at this stage is to receive relevant evidence and to rule based on the record and applicable law without reaching the merits of those claims in advance. The parties have filed public motions outlining the anticipated evidence and testimony related to the motion to disqualify, including the state's opposition, the defense reply and request to take evidence, and the defense original motion. Those filings describe the general subject matter expected to be addressed at today's hearing. If the adult child witness is called to testify, which is the request at this point, the court will consider that testimony as part of the evidentiary record. After careful consideration of the record, the arguments of counsel, and the interests identified in Utah Rule of Judicial Administration 4-202, the court finds that closure of the adult child witness's testimony is not necessary and would not be narrowly tailored under the circumstances presented. The court further finds that the interests of openness and transparency outweigh the asserted grounds for closure as to that testimony, and that the rights of the parties and witnesses can be adequately protected through least restrictive means available to the court. For those reasons, the request of both the state and defense to conduct the adult child witnesses' testimony in closed session is partially denied. The court acknowledges that Utah Rule of Judicial Administration 4-202 permits limited closure of court proceedings in appropriate circumstances, and also acknowledges the concerns raised regarding the personal privacy and the safety of the adult child witness. This court's responsibility is to balance those concerns with the constitutional rights of the parties and the strong presumption in favor of open and transparent judicial proceedings. Therefore, the court finds that a brief and narrowly tailored procedure is appropriate to address these competing interests. Accordingly, the courtroom will be temporarily closed, and all parties and members of the media will be excluded for the limited purpose of calling the adult child witness to the stand to state identifying information. Once that limited portion of the proceeding is complete, the courtroom will be reopened and members of the public and the media will be permitted to re-enter. During the testimony of the adult child witness, no audio or video transmission will be allowed and no photographs of the witness will be taken. At the conclusion of the adult child's witness's testimony, audio and video transmission of the hearing will resume and will continue through the remainder of the proceedings. The court finds that this procedure is narrowly tailored, uses the least restrictive means available, and appropriately balances the interests of witness safety and privacy with the public's right to observe these proceedings. We will proceed accordingly. We will take a brief.
So basically, it's closed to the public. It's not closed to the witnesses and family members and stuff in there, but it is closed to us.
Yeah, I don't agree with that. They could, I mean, the camera, it could just be audio. They could point the camera down just so you hear the questioning, because after the introductory questions, identifying questions, all of that, that's when the media and the public are going to be back in the courtroom. I don't see why they couldn't just go audio only, just point the camera down and where we can hear audio so that you can't see who this person is, unless they're worried about somehow there's a way to identify someone through their voice. Yeah, I'm disappointed in this one. Because partly think about this, Matt, think about the insight that we probably would be gaining from just someone there that day in a court setting on just exactly how vivid they remember things. I think it would be quite telling. Quite frankly.
And also if they're being groomed by the parents or someone else to say a certain thing to fit a certain narrative.
Yep. And strangely enough, Matt, if you think back, when it was Jeff Gray on the stand last hearing, defense counsel asked the question, had you or anyone in your office been visiting or met with the witness? And out of all the questions that the DA answered, that was the question that was the ambiguous, I can't remember, I'm not sure. So at that point it becomes, is the state's office, are they representing the witness as well? Which is kind of the crux of this whole thing, with the lack of just legwork that the DA did on consulting with or talking with the state AG's office. I mean, it was they didn't even go there. Why? You know, you could at least fire an email off at the very minimum, but none of that happened, right? They just felt like they, everything passed their litmus test. And, but I found that answer last time very, very telling in terms of the amount of attention or meeting with the witness. That would be the child of the associate district attorney.
I think we lost Kelly. Let's talk about her.
I think she got another award. Kelly, did you get another award while we were?
Of course I did. Of course.
Did they just drop one off for you? I mean, like, girl, you're doing it. You're killing it. Good job.
Oh my gosh.
We
No,
didn't hear any of that.
I was actually pulling up some different court documents and I was doing it from my iPad because I was worried about touching the stream just out of an abundance of precaution. But I wanted to call attention. I'm going to pull up in just a moment that protective order that Erica Kirk had requested. But first, Trigger, if you would mind pulling up this document number 2. Sorry, I didn't have a chance to change the name of it yet, but
Did you already share it?
yeah, it's loaded in the bottom. Okay, so this is from early on. I guess I'd skimmed over this maybe initially, but I just found this very interesting. So this document appears to talk about maybe his risk assessment for Tyler. And it appears that he's about as green as they come. So, obviously they've chosen to not release him, at least to our knowledge, give him any sort of bail in the meantime, or grant him any sort of bond. But I just found that to be quite interesting. I guess that's what happens when you don't have any criminal history going into it, and then whatever assessment that they do upon intake.
Now, playing devil's advocate, just because you're green doesn't mean you're innocent.
Oh, I'm not implying that at all. I just mean that.
But it's interesting.
Yeah, I just think it's worth noting.
No, look, y'all, this is very interesting because when you go in, you are subject to a number of not intense questions, but they're finding out things when you are going through the booking process. And this right here, look, there are individuals that definitely fit the criteria of the deeper, darker shades of red there, orange. And this is just very, this makes sense to me, right? Because I look at Tyler and I see a kid that is caught up in some shit that he had stuff that he had absolutely no clue possibly that it was going to be at this point here. And also for classification purposes inside of the jail housing. You're not going to have somebody sitting there at a red classification and they're going to be in general population. Not that I think Tyler is even in general population anyways. But this here just kind of goes to the psyche or the mental stability or stableness rather of someone. And with him being there, I mean, you're talking about aggravated murder and is circled in one of the lowest classified, areas there. It's interesting.
Well, and then also when you add in the fact, dare I say, pomp and circumstance, that's not the right term, but the over the top way that they usher him into the court and out of the court in this armored vehicle with lights and sirens ahead and behind. I mean, it is over the top. So I'd never seen this before. I hadn't seen anyone talk about it before, so I wanted to bring it up while we're.
Yeah, I've never seen this. Where did you
From the court
It's-
website. Yeah.
So they put it out the day after, or I'm seeing date created 9/12. So this would have been when he was booked,
Yeah.
right?
Yes.
Interesting.
Is there another page to it? I can't remember. Okay, so that's just continuing to explain what those other sort of shades of red. It would be, sorry guys, it would be easier if we could kind of see it all together, but these little categories explain what requirements would be expected if a person met those deeper shades of red.
Wow. Well, to me, things are going to be done for the day. I don't see this thing coming back online today, at least, which kind of plays into the reason I did not go there. Matt, what do you think? You think they get through a whole witness, both sides, direct, cross, redirect, with a matter of a couple hours, and all this ushering people in, ushering people out? I don't see it.
Unless they can disqualify her pretty quickly.
True.
Unless they find something right away that is a conflict of interest and that allows them to make a ruling. But
Right.
yeah, I mean, at the speed things are going, the speed of smell could be interesting.
The wheels of justice turn slowly. But, we
are we
try
gonna
to
have
add
her
a
dad?
little grease in there when we can.
Oh, Kelly, you from the South.
I am.
Are we gonna? So we're gonna have her father as well, right? And then that was all to be called as witnesses on this motion. Was DA, daughter witness, father associate ADA? Was that the list?
I believe so. Let's see.
Okay, Matt, I also put in document 3, if you want to flip to that one while you're searching around, then I can talk people through this. Okay, so this is the pretrial protective order that was filed by Erica. I had also the one that was initially proposed. This is the one that was ultimately ordered, so granted. And yeah, you can see that the victim needing protection would be Erica Kirk. Defendant Tyler James Robinson. Interesting that they didn't put Erica's middle name in there. Okay, I wonder if she has one. I mean, maybe it changes. Kind of like apparently her mom has listed her birthday as a couple of different days, but it's fluid situation. The court finds that the defendant represents a credible threat to the physical safety of the protected person. The protected person is not an intimate partner or cohabitant. Well, I guess not anymore, but is an alleged victim. Yeah. The court orders you, the defendant, must obey all orders marked below. No domestic violence or abuse. You must not threaten to commit or commit any acts of domestic violence or abuse, harass, threaten, stalk, use, attempt to use, threaten, use physical force that would reasonably be expected to cause bodily harm, or engage in any other conduct that would place the protected person or designated family or household members in reasonable fear of bodily injury. Those designated family members include, and then it says, no, let's see, was there a number? Oh, there. Okay, sorry, I pressed it twice. Oh, wait, no, it didn't. Okay. It didn't include any names, so I don't know if they redacted that out or what. But then no contact or limited contact. You must not harass, telephone contact, or otherwise communicate with the protected person directly or indirectly, including email, text, social media messaging, or posts mail, or other methods of contact. I'm sure that that's what Tyler's real worried about right now is getting on X so he can tweet.
No, this is just filling out the character. That's what
Mhm.
this is. They're just completing the character.
Defendant cannot live at protected person's residence. Okay. You must not go to the protected person's residence or premises without an officer. Remove yourself from, stay away from their residence. And then also stay away. You will not violate the protective order by attending a hearing with the protected person. But
Yeah,
you
this
yeah.
feels very domestic violence. Not even
It
anything
does. I mean,
applicable.
I hate to read it, but the reason why I am bringing it up is just because it struck me as odd when I first read this at the beginning of the case. I'm like, man, this is over the top. Obviously, the guy's behind bars. It's one thing if he's, if he's going to be released, then okay, you file something to set some sort of boundaries and parameters if you are indeed concerned, but there's no evidence that we have heard of thus far from anyone that Tyler had ever communicated with or threatened the Kirk family in any form prior to.
No, that's why this just feels like such a stretch, because absolutely nothing in there speaks to really anything. This is just basically to solidify and mold more of a public opinion of us being forced to look at Erica as a victim rather than what actually happened. This
Yep.
is just a very, very this feels very like a formality, and it's not even applicable, which is
Yep.
yeah, you see these with baby daddy, baby mama arguments, not Patsy running on the roof.
So it
Or,
looks like
excuse me,
Brandy, for anyone that was actually gonna tune into Billy and Brandy's stream, it looks like they're moving it up another hour because they want to be there for this adult child witness. And it looks like, let's see, trying to see if there's any other information in there. Yeah, it looks like they're going to stay through the witnesses, so they're going to be doing interviews and things after everything is done, it looks like. And ask them if there's the same witnesses there, like Travis and all those people. So we'll see what they say.
hey Matt, real quick, touching back on the comment from the judge, or not, no, it wasn't the judge, it was state's attorney, about the amount of video on Discovery, 300 terabyte.
Terabytes. Yeah.
I'm sitting here looking, we're talking 4K video, 20 to 30 bit rate, like days of continuous recording is showing 900 some odd days to 1400 some odd days. Like, I wouldn't even know how to measure that. Does that sound normal for a university? 300 terabyte? Like, that's incredible. Like, that is a boatload of data.
So, okay. Actually, this would be a fun little adventure for us to do. While you guys are talking that out, I'm going to pull up another document, which is all of the things that the defense had asked for.
Yeah, I want to see that. But I definitely think it is reassuring to hear them talking about it, that it sounds like they're going to go even back to the week or two prior, because you remember there was someone spotted on the Losi Center roof, what I think we all can assume was someone doing recon or kind of a planning, if you will. So hopefully we'll be able to have that, but that just seemed like a lot of data. And where's it stored? Is it stored offsite? I wouldn't even know what 300 terabyte look like. I'm sure it's a data room. I don't want to call it a data center, but maybe like a data room there at the university. That just blew my mind. 300 terabyte.
Yeah, I'm having to do some calculations here really quick. When it gets done, I might have something to add to that.
Perfect.
If you'd like, Matt, you could pull up slide. It says slide 1, and I can start looking through that.
There you
and
go.
getting us to the right page. Thank you so much. And feel free to just chime in whenever you're ready. But guys, this is the formal request for discovery. So it's going to take, I can't remember how many pages this is, so bear with me for a minute, but it has a nice long list of, oh, here we go. Pretty close to the top. Let's see, maybe I can, I'm going to zoom in here. Try to stress my eyes out.
Hey,
Okay.
Kelly, before you start, I'm
Yeah, go for it.
I've got a 4 o'clock meeting, so I'm gonna duck out. I'll be back when it's over.
All right, and here's the quick calculations. So 4K cameras, 300 terabytes over 30 days, they said. That comes out to roughly about 100 cameras on campus.
Mm.
And that's about 10 terabytes per day per camera.
Somebody in this chat should see if I don't know, any of the either side is hiring, because there's no way they're going through all this stuff in-house. Let's be honest. I guarantee you they've outsourced something for someone to go through and file. I mean, God, it would take them so long to go through every minute of that video and log every minute.
Yeah. You know what just really bothers me is that I hear his defense attorney, and look, I think everybody probably on Matt's audience, Kelly's audience, certainly my audience, they know where I stand on things. It's really bothersome to hear the defense attorney call it the shot. Like it just bothers me to hear that. Like I would, if I was Tyler's attorney, I would not be referencing to the action as a shot. I just couldn't. So that really calls into question, like, how much are y'all looking at? Like
Right.
it's just very, very troublesome. So you bring up a great point. Who's going through all of this? Do they even know where to look? Like, do they even know to go to the Losi Center roof 2 weeks before, where we have that audio of that eyewitness that actually talked to the person? These are all things that I don't see. That's a lot of data. Like, do they even know what to look at? Do they know what to look for? I could at least aim for a right day and look for something there. So that's just something interesting there.
Well, especially
I'll see all
if
that.
it's manual. If it's done manually, human error is going to make it so they're going to miss something. A lot of times, yeah, and sometimes they have AI. But I know a 4K murders any computer. So going through 300 terabytes on multiple machines, that's going to be a painstakingly long process and very slow. But someone said in the chat, their site says they have 1,400 cameras on campus. So while there may be 1,400 cameras, this is saying that 300 terabytes would only be needed for 100 cameras. So they must have it kind of dialed into where they think it's going to be. I'm assuming in the courtyard and on the Losi Center, I'm guessing in most cases.
And probably also any entry points to the campus to be able to pick up vehicles that would have come in or out. So that way they could, sort of triangulate when he's.
How do you even share 300 terabyte? What does that even look like on a Discovery share? Matt's like grinning. Do you take a U-Haul, like a box truck of servers over? What does that even look like?
They're downloading it 24/7. I think he said.
It's like, hey, do I need to bring my my hard drive here with me to plug in? Literally like 300. Like, that's crazy. That's big.
Well, the other thing too is, like, these cameras and this data doesn't necessarily say it's all from UVU footage, or did they say that?
No, they did. No, I don't believe they said it. They just.
It could be from Ring doorbells, from people down the street. It could be all over town surveillance, as far as we know.
We hope the hospital,
Dairy Queen, the steakhouse, his grandma's house.
I know how my Ring or my doorbell camera looks, and I can have like a 10-minute recording that's like 128 megabytes. So if we got some big files of Ring doorbells, I better be able to count the whiskers. It's that crystal clear.
The whisker.
I don't think any are 4K,
I
are
hope.
they?
No,
I think
I
most are
don't.
1080.
I think actually Eufy has some new ones that are out that do go 4K. But that's at the doorstep. But no, usually it's been 720 or 1080. That's been kind of industry standard. All right. I will see y'all back here in a little bit. Thanks for having me on, guys.
Thank
Appreciate it, Matt.
you.
All right, later, break. For anyone that is watching, make sure you hit that like. Make sure you subscribe if you're not already subscribed to myself and Kelly Raybon. And at this point, we don't know when or if they're going to come back. So I figure we give it a little while and see if they actually show back up. And if they don't, or if it keeps dragging out, then we might end the stream. I know
Okay.
the last time we did this, it was about 5 hours. And Kelly, if you're talking, I think you're muted. Maybe?
Can you hear me? Can you hear
Oh,
me?
there we go.
Okay. I was thinking that while I rattle through this list of the disclosure that they're requesting in the discovery, if people in the chat wanted to say what would be, if you could ask for one piece, if you were on the defense side and you were saying, hey, state of Utah, this is the most important thing that I want for discovery, what would be the one piece of evidence that you would ask for from them? Are you making one of those question things in yours?
Yes, a
No?
poll. Yes.
Okay.
But mine is, do you think they have more video of Tyler on the roof? Yes, no,
Okay.
or it's probably AI.
Let's see. Hold on. I'm going to start. Now, if I do the start a Q&A, does that just record all of their answers in one spot?
It records all their questions.
Oh, their questions. But I mean, it would be an answer if I'm asking them for an answer, right? Like if
It could
I'm
be what, yeah, it can be
Yeah.
whatever input you want, technically.
Okay. Okay, guys. Y'all just put it in the chat. It's fine. I'm not going to get too crazy with this. Oh, I'm working up to it. Okay. Yeah, so tell us what you think. And I'm going to be reading this. So Matt will keep an eye on what you guys are saying. All right. So the defendant requests that the prosecution team comply with mandatory disclosure obligations, written or recorded statements of the defendant and any co-defendants, and the substance of any unrecorded oral statements made by the defendant and any co-defendants. Well, that's just Tyler at this point. Reports and results of any physical or mental examination, of any identification procedure, and of any scientific test or experiment. I do think that would be interesting to learn more about how they determined that the guy in the stairwell was the guy they believed to be the shooter, and ultimately, how they connected all of that to Tyler, with the exception of his parents supposedly bringing him in for questioning, which, by the way, Matt, I think they believed, in my opinion, I think they believed they were bringing him in for questioning, not turning himself in to be arrested. But that's my theory.
And they just kept him, huh?
Yeah.
Yeah.
Yep. He thought he was doing the right thing by going in to be questioned. And his parents are like, okay, yeah, let's get this taken care of. And the next thing you know, bro's locked up. Okay. Physical and electronic evidence, including any warrants, warrant affidavits, books, papers, documents, photographs, digital media recordings, written or recorded statements of witnesses. Obviously, we know that, well, I say obviously, we would think that would be voluminous, but according to 2 weeks ago, when we had the opportunity with Billy and Brandy to interview Travis, who was one of the witnesses there at UVU when the incident happened. He said that merely just 10% of people, or gosh, even less than that, 1%. He said there were only 30 people, I think, who'd submitted witness statements out of 3,000. Strange. Reports prepared by law enforcement officials and any notes that are not incorporated into such a report. I love that that's bolded. As an investigative reporter in my past life, I can tell you that is where the gold is. It's just a matter of if they turn it over or not. Evidence that